webinar focusing on children associated with armed groups designated as terrorists, and that's hosted by the CAAFAG Task Force. The webinar is going to last about an hour and a half. The majority of the first hour will be taken up by 3 presentations that we have for you today, and then we'll have roughly about sort of half an hour at the end for questions and answers. But I know from experience that we will have a hard stop at 3:30 UK time, and we'll get chucked out of our Zoom link then. So we will do our utmost to make sure that we fit everything in. If people do have questions that we're not able to get to, we will take them and respond to them afterwards though. If people are interested in asking questions, they're encouraged to do so via the chat that they have with them, and we'll also be monitoring the Q&A session. The last point is that, as you may be aware, there is simultaneous translation that is available for this, this webinar. If you need translation into French, Spanish or Arabic, if you go to the bottom of your Zoom screen, you should be able to see the links to those translations available to you. Before we come to the main topic that we're going to be discussing this afternoon, I do just want to hand over to Sandra and Gio from the CAAFAG Task Force to give a bit of information on the work of the task force and the purpose and the reason why we have this webinar this afternoon. Sandra, over to you. Sandra, can you hear us?
Thank you, Christine. So hi, everyone. Just want to say that I'm very pleased to see so many participants to this webinar. So I'm Sandra Maignan. I'm co-leading the CAAFAG Task Force with Giovanna. And just to say that this webinar is part of a webinar series that we are organizing with the CAAFAG Task Force. And that it's also, as we said, live stream, and we can still follow with questions on the community of practice. Giovanna, would you like to say a few words?
Yes, just very shortly. Hello, everyone. My name is Giovanna Vio. I'm a consultant with UNICEF on children associated with armed forces and armed groups, and I co-lead the CAAFAG Task Force with Sandra, and just looking forward to the discussions today. So, yeah, over back to you, Christine. Thanks.
Thanks very much. So the recruitment and use of children by armed groups designated as terrorists is not a new phenomenon. We're all familiar with the recruitment and use of children in northern Uganda by the LRA, and also in Sri Lanka by the LTTE, and it's well recognised that these 2 armed groups were designated as terrorist organisations. We also are familiar with how the recruitment and use of children in those contexts was responded to by child protection agencies and the international community that are working effectively with children and families and communities on programming and interventions to address vulnerability to recruitment and to support the safe and meaningful reintegration of children who have been recruited by those groups. Importantly, we also are very familiar with the work that was done by agencies and generally by the international community in recognition of the rights of children who had been recruited by the likes of the LTTE and LRA. So we know that we have experience of acting correctly in relation to children who are recruited by designated terrorist organisations. In recent years, we've seen an increase in conflict, particularly where armed groups designated as terrorists are present, and also seeing the international community's reaction and response to those groups. We've also seen a continued increase in the recruitment and use of boys and girls by parties to conflict, including, but not only, armed groups designated as terrorist. And although child protection agencies are continuing their work with children and families and communities to address recruitment and to support reintegration, we are seeing increasingly that children who have been associated or recruited by armed groups designated as terrorist are facing particular challenges in relation to the respect of their rights, particularly to be released and reintegrated and to have a meaningful progression into adulthood, but also having challenges in access to reintegration support. And this includes having the risk of detention for actual or perceived association. Today, we're delighted to have a number of experts from key child protection agencies who will speak on this issue. This includes Julia Jorin from ICRC, who is a child protection advisor. We have Janine Warner from Watchlist, and we have Bridget Kennedy-Pfister, who's the Senior Child Protection Specialist from UNICEF. Julia, Janine, and Bridget will be discussing important considerations in supporting the rights and needs of children who have been recruited and used by armed groups designated as terrorist. Following that introduction, I will hand over straight away to Julia from the ICRC. Thank you, Julia.
Thank you very much, Christine. Hi to everyone. And thank you for inviting the International Committee of the Red Cross to join the discussion today. This session serves a pressing purpose. Children associated or perceived to be affiliated with an armed group designated as terrorist are more at risk of having their rights violated. The ICRC is concerned by the persistent legislative trend that treats children labeled as terrorists as exceptional cases to whom pre-existing international law does not apply. It therefore merits emphasis that the children we speak of remain entitled to the legal protections they have by virtue of their identity as a child under both international humanitarian law and human rights law. I would thus outline the legal framework applying to children in the context of armed groups designated as terrorists. Now, before going into legal aspects, I would like to briefly dive into the historical background out of which legal and humanitarian developments grew. The unlawful recruitment and use of children by armed forces or armed groups who engage in extreme forms of violence against civilians is not new, as we have already heard from Christine. And indeed, the issue of child soldiers, as they were then called, became an operational priority for the ICRC in the 1990s. The adoption of the optional protocol to the Convention on the Rights of the Child on the Involvement of Children in Armed Conflict in 2000 drew attention to the plight of children affected by wars and marked a significant step towards the prohibition of the recruitment of children that had been so widespread in the 1990s. And subsequently, against the backdrop of the continuous widespread use of CAAFAG in several wars in various parts of the world, the ICRC, alongside UNICEF and other actors, engaged in the drafting process of the Paris Principles and Guidelines on Children Associated with Armed Forces and Armed Groups of 2007. And the Paris Principles have since been endorsed by 112 states. Now, in the past couple of decades, there has been a proliferation of armed groups in different regions, some of which have been designated by states or UN listing procedures as terrorist. In this context, some states have pursued a dehumanizing rhetoric, which treats individuals with perceived links to terrorism as undeserving of the protection of international law. And legal and policy frameworks have been developed to counter the threat posed by non-state armed groups designated as terrorists, often characterized as exceptional. Children who are perceived as having an affiliation to terrorism, whether in their own right or through family members, or because they live in proximity to or under the control of an armed group designated as terrorist, are promptly viewed not primarily as children, but as security threats, in disregard of the fact that all children are entitled to specific protection under international humanitarian law and international human rights law. So the concern at hand is that while the international legal framework protecting children in armed conflict is actually strong, as soon as a child is labeled terrorist, different sets of laws may be applied, which may be at odds with the strong legal framework, and at the same time, the pre-existing legal framework applying to CAAFAG may be put aside. So going to the next slide. The ICRC considers it legitimate for states to take responsive action to ensure their security. However, in doing so, it is mandatory that they maintain the safeguards protecting human life and dignity laid down in international humanitarian law and international human rights law. Indeed, the designation of persons as terrorists or the terrorist nature of the acts they may have committed may in no way be invoked as a justification not to grant them the rights and protections they are entitled to under international law. Now, on labels and terminology, international humanitarian law explicitly prohibits acts of terrorism, among other provisions in additional protocol 2. The law of armed conflict therefore provides a strong legal framework with explicit prohibitions applicable also to non-state armed groups designated as terrorists. Indeed, committing acts of terrorism, for example, attacks aimed at spreading terror among the civilian population, indiscriminate attacks, or mass unlawful killings, entail individual criminal responsibility, both at domestic and international level. However, while IHL regulates specific acts, it contains no definition of what constitutes a terrorist or a terrorist group. And in the absence of an internationally agreed definition of terrorism, whether an individual is considered terrorist or a group is classified as terrorist depends on the decisions of states and can be subjective. We have seen how this label has entailed risks for children. Definitions, designations, and labels are important as they may shape the extent of the legal and protection framework applicable to a child or the interpretation thereof made by stakeholders. Designations of persons as terrorist or violent extremist or foreign terrorist fighters can be used as masks justifying dehumanization and ultimately the non-observance of legal protections. Now, on another note, when we talk about a child associated with an armed force or an armed group, the meaning of the term associated is that of the Paris Principles that define a CAAFAG as any person below 18 years of age who has been recruited or used. Noting this clear definition, it is important to distinguish between children who have been recruited or used and those children who may have been forced to live under the territorial control of an armed group or who have family members who are linked with an armed group, but where the children themselves are not associated with the armed group. To avoid unintentionally reinforcing a narrative that these children are trained or dangerous, they should not be referred to as associated with a group designated as terrorists. Hence, when we speak about children in the context of armed groups designated as terrorists, international humanitarian law, or IHL, the law applicable in armed conflict, recognizes two categories. The first is the category of all children. This includes children who have not been recruited or used, but who are otherwise perceived to have links to armed groups designated as terrorists. And the other category is the specific category of CAAFAG, as per the definition in the Paris Principles, referring to children who have been recruited or used by an armed force or an armed group and who are therefore associated with that group. Legal standards applicable to all children in armed conflict, the first category. So armed conflicts opposing a state and an armed group designated as terrorist are non-international armed conflicts. These situations are governed by Common Article 3 to the Geneva Conventions, customary IHL, and additional Protocol 2 to the Geneva Conventions of 1977 for those states that have ratified the latter and for conflicts where it applies. So children are covered by the fundamental guarantees for persons not taking direct part in the hostilities. And key is the requirement of humane treatment, which applies to all persons in all circumstances. Of course, what is humane treatment for an adult may not be humane treatment for a child. Under IHL, humane treatment is context-specific and needs consideration in the concrete circumstances of each case, including in light of the person's age. Then IHL also requires the maintenance of family unity to the degree possible, and it further affords all children special respect and protection. The principle of special respect and protection requires that states take the necessary measures to ensure that children are granted the special care and protection they are entitled to. These are the legal protections they have by virtue of their identity as a child, and this principle is reflected in the obligations that apply specifically to children. In this regard, the 4 key areas under IHL are obligations to facilitate access to education, obligations applying to children in detention, which I will touch upon in a minute, restoring family links obligations, also known as family tracing and reunification, and the prohibition of recruitment and use in hostilities. There are differences in obligations around the age of recruitment, depending on the treaties a state is bound by, but most commonly the age of 18 applies to recruitment by non-state armed groups. Rules of IHL are complemented by rules of international human rights law. So in the context of children with perceived links to armed groups designated as terrorists, who are often stigmatized and deprived of their rights by virtue of family relations, the principle of non-discrimination is worth emphasis. Among other places, it is set out in Article 2 of the Convention on the Rights of the Child, which stipulates that states parties shall take all appropriate measures to ensure that the child is protected against all forms of discrimination or punishment on the basis of the status, activities, expressed opinions, or beliefs of the child's parents, legal guardians, or family members. States parties to the Convention on the Rights of the Child are also required to take all appropriate measures to promote physical and psychological recovery and social reintegration of a child victim of armed conflicts. Now, regarding the other category, specific obligations apply to children associated with armed forces or armed groups, regardless of whether those armed groups have been designated as terrorists. Among them are children who have been unlawfully recruited are entitled to measures of support for their physical and psychological recovery and their social reintegration. And it's worth mentioning that Security Council Resolution 2427 of 2018 stresses the need to pay particular attention to the treatment of children associated or allegedly associated with all non-state armed groups, including those who commit acts of terrorism. This resolution further encourages the establishment of handover procedures for captured children to civilian child protection actors. So we can consider that handover procedures are an interpretation of what it means concretely to grant CAAFAG special protection of their right to recovery and reintegration. In the event of their detention, children unlawfully recruited by an armed group designated as terrorists continue to benefit from the special protection to which children are entitled. In line with this, children must be accommodated separately from adults unless they are with family. Children must have age-appropriate access to food, clothing, medical treatment, access to education. And the principle of special respect and protection should also be interpreted to mean that alternatives to detention should be considered. Child recruits should be treated primarily as victims of violations of international law, and Security Council Resolution 2427 urges states to consider non-judicial measures as alternatives to prosecution and detention that focus on the rehabilitation and reintegration of children formerly associated with armed groups, and thereby reflecting the Convention on the Rights of the Child, as well as the optional Protocol on the Involvement of Children in Armed Conflict, as well as the African Children's Charter and the Paris Principles. The Paris Principles further establish that recruited children should not be prosecuted solely for their membership in an armed group, and this is also the ICRC's position. Child justice law and standards also require that children be exempted from the death penalty. And in conclusion, I recapitulate, IHL applies to persons affiliated to terrorism as it does to any other. All children, including those associated with extreme violence, should be regarded primarily as victims and children and treated as such. This point is imperative. It cuts to the heart of what it means to be a child, and reassuringly, it is addressed comprehensively by the existing legal framework. Thank you.
Thanks so much, Julia, for a very informative presentation. An awful lot of very important information there. Janine, if we can come to you, and I understand you will be talking more around detention of children, amongst other things. Thank you.
Okay, thank you so much. Okay. So yes, thank you everybody for being here today, for giving us the opportunity to talk to you about this really important topic. As my colleague Julia has touched on in her presentation, despite an international legal framework that calls for children to be treated primarily as victims, many children are detained for their perceived or actual affiliation with a designated terrorist group. As you can see from the slide that I have up here, which is based on data from the Secretary General's 2021 annual report on children in armed conflict, governments and non-state armed actors have detained at least 3,243 children in 20 countries for their alleged or actual association with an armed group, for national security reasons, or for alleged family ties to an armed group or force. This is in part driven by governments being empowered by new or amended counterterrorism legislation, where they're more likely to treat children affected by armed conflict, including those who have no known history as combatants, as security threats or criminals, and to detain them for long periods of time, sometimes without charge, often in facilities that do not meet the needs of children. Governments are sometimes also subject children to prosecution for mere membership in a designated terrorist group in violation of international standards. In some countries, that counterterrorism legislation is so broad that children may be considered associated with an armed group or force based on a number of non-criminal activities. So that could include things like participating in religious courses or working as cooks or selling vegetables. As Julia mentioned, sometimes children are classified as members of an armed group because of a family member's association with that group. These laws that are criminalizing association fail to recognize the unique vulnerability of children as targets for armed groups and the spectrum of coercion that might lead to their membership. So in addition to forcible recruitment by armed groups, children join for a variety of reasons, because of financial incentives, lack of access to education, lack of social relations, to gain social status, to escape family problems. It's rarely ideology that's the primary driving force or motivation for a child's membership in an armed group. Once children are branded members of a particular armed group, especially certain groups designated as terrorist, they may face stigma from their communities, hindering their ability to reintegrate back into society and to support themselves. So what, as child protection advocates, can you do to support children who have been detained for their perceived or actual association with a designated terrorist group? For this presentation, I'm going to focus on two possible areas of engagement. The first is negotiating agreements to promote the handover of children in military detention to child protection actors for their reintegration. The second is really engaging in long-term advocacy to strengthen the legislative protections for CAAFAG nationally. So I'm going to start with one of, I think, the primary agreements in this area, handover protocol agreements, that are really one of the primary tools for child protection actors who are looking to promote the release of children in military custody to child protection actors. So handover protocols are defined or are agreements by a government or an armed group, often supported by the UN, to transfer children from the custody of security actors or whom have been encountered in other circumstances to civilian child protection actors for support services, including but not limited to reintegration assistance. They typically include provisions on the treatment of children while in the custody of security forces and details about notification and handover procedures. Historically, handover protocols have been initiated and led by UNICEF and or child protection advisors in UN peacekeeping missions. In some countries, the UN has partnered with the ministry responsible for the protection of children, and the two have jointly led these negotiations. NGOs typically play an important role in implementing these protocols by providing support or interim care and reintegration support. So in the diagram on the right, which I pulled up in the previous slide, you'll see a number of black dots, and those indicate places or countries where handover protocols have been signed, which I believe at this point is 10 countries. There are 2 countries that are not included on this diagram, and that's Burkina Faso and Nigeria, where handover protocols were just signed earlier this year. 9 of the handover protocols have been signed with governments, and 1 has been signed with a non-state armed actor, the Ansar Allah, which was formerly known as the Houthis in Yemen. In most of these countries, the impetus for negotiating the protocols was the number of children allegedly associated with armed groups, sometimes designated terrorist groups, were being held in the custody of military actors, sometimes arbitrarily, and child protection actors were looking for ways to promote their release. So, for example, in Niger, there was a surge in military operations to counter Boko Haram in about 2015 in the Lake Chad Basin. And in that case, the UNICEF country office in Niger advocated for the transfer of those children to a juvenile justice center and began negotiations for a handover protocol to secure their release. Nigerian authorities signed a handover protocol with the UN in February of 2017. And now, under that same protocol, many CAAFAG associated with terrorist groups are directly handed over to child protection actors for reintegration. As I mentioned before, more recently this year, Nigeria and Burkina Faso also adopted handover protocols, and those negotiations were initiated to ensure the consistent release of children detained for an alleged affiliation with designated terrorist groups in those countries. I think it's important to note that handover protocols are not guarantees of immunity. So if a child is suspected of a very serious crime, an internationally recognized crime, something that's beyond mere association with an armed group, he or she may be prosecuted in line with international juvenile justice standards, where the judge considers his or her recruitment a mitigating factor in those criminal proceedings. So I don't have a lot of time to go into the nitty-gritty of handover protocols, but you see on the left the cover page of an optional guidance, operational guidance rather, that was put together by Watchlist and the Alliance, which has a number of tips on how to successfully negotiate handover protocol agreements. It's available on the Watchlist website. It's also available in French and Arabic, so I definitely encourage you to take a minute when you can to take a look at the details of those agreements. So while handover protocols are in many instances the kind of primary tool for negotiating the release of children in detention, there are a host of other agreements that can lead to the release of children. This is not an exhaustive list, but I thought I'd just give you some examples of other areas where we've seen child protection actors successfully negotiate the handover of children from military custody. So the first is action plans. As some of you in this group may know, the listing of a state armed force or a non-state armed group in the annexes of the Secretary General's annual report on children and armed conflict opens the door for the UN to formally engage with that listed party to develop an action plan to end the violations for which it's listed, and in some cases, other related children's rights violations as well. Following the listing of the Chadian armed forces and the Sudan government security forces in the Secretary General's annual report in 2007 and 2006, respectively, these governments entered into action plans with the UN to address grave violations for which they were listed. And as part of those action plan negotiations, Chadian and Sudanese authorities signed handover protocols. So Chadian, they signed in 2014, and Sudanese authorities signed in 2018. And those protocols were designed to release children, or any children who were in military custody. The second area is peace or ceasefire agreements. So basically any agreements that are kind of outlining the responsibilities of armed forces at the end of a war can also be really important places for promoting the release of children in detention. So before the coup in Sudan in October 25th of 2021, the UN had began negotiating a roadmap with various armed groups as part of the Juba Peace Agreement to implement several different activities, including the signing of handover protocols to transfer children in their ranks or from opposing groups to forces to civilian child protection actors. And similarly, the FARC and the government of Colombia signed a joint communique number 70 in May 2016, which also called for the immediate separation of children under the age of 15 and for the reintegration of all children under the age of 18. Another kind of agreement that I wanted to highlight are national disarmament, demobilization, and reintegration frameworks, otherwise known as DDR frameworks. So for example, if you look in the Democratic Republic of Congo, the government there has signed a UN action plan with the UN, and rather the Congolese National Army has signed, the government of Congo has signed an action plan with the UN, and that is complemented by a DDR framework, which outlines the roles and responsibilities of the state to transfer associated children to child protection actors. In some countries, national legislation has been adopted to ensure protections for children in military custody. So for example, in the Philippines and in Myanmar, they have adopted national legislation that provides for the handover of CAAFAG to civilian actors. So in the Philippines in 2019, the government signed into law an act providing for the special protection of children in situations of armed conflict and providing penalties for violations thereof, very, very long title. And that requires authorities to transfer children that are detained in armed conflict to the local social welfare and development officer within 72 hours. In some countries, presidential pardons are also used to try and promote the release of children. So we know in Somalia, children who had been involved in a conflict in Puntland were placed on death row, and child protection actors advocated for a stay on their execution and pushed for authorities to release those children into reintegration centers. And finally, amnesty. In some contexts, child protection actors have engaged in individualized advocacy for the release of children who, for example, have limited evidence of affiliation with a particular group or who have special medical needs. So in Iraq, there is an amnesty law that was passed in August 2016, which theoretically offers amnesty to any individual who joined ISIL or other armed groups characterized as extremist against his or her will, or who did not commit any serious offense. And we know of a case in that particular context where a special committee of judges in Nineveh, working with a general prosecutor and a social worker, used this law to release some children for participating in ISIL training for between 7 and 30 days before turning 18. And there was no evidence that those children had engaged in other ISIL activities. So in addition to negotiating agreements to promote the release of children with a perceived or actual association with a designated terrorist group from military custody, child protection actors can also engage in longer-term advocacy to strengthen national legislative protections for CAAFAG. So on this slide, you'll see a summary of some of the key areas for advocacy. I've just narrowed it down to 3. The first, I think, is really to ensure that national juvenile justice laws are in line with international standards. The juvenile justice system is really a critical component of a country's overall child protection system. And a strong juvenile justice system will help to support the release of children detained from mere association to child protection actors, and will promote non-judicial measures as alternatives to prosecution and detention for children suspected of committing international crimes during their association. Julia has already outlined, I think, some of the special protections for children who have been unlawfully recruited by an armed group designated as terrorist. Maybe just a few things to add that you may want to consider in a national context. First, prosecution of CAAFAG should only really happen in exceptional circumstances. So the decision to bring a case against a child is at the discretion of a prosecutor rather. And there are contexts where a prosecutor has chosen not to go forward with prosecutions. So for example, when we look at the special court in Sierra Leone, the prosecutor in that context decided not to pursue any prosecutions of CAAFAG who had been involved in the war. The second thing to mention is that a specialized juvenile justice system or a civilian court, which has personnel who are trained on child-friendly procedures and are connected to child welfare systems, should have primary jurisdiction over children investigated or charged with crimes during their association. So that shouldn't be within the jurisdiction of the military courts, intelligence, or national security, or other special courts. They should really be in under the civilian jurisdiction. A third, we need to make sure that the minimum age of criminal responsibility should at least be 14, ideally higher, per the recommendations of the UN Committee on the Rights of the Child. And then fourth, I just wanted to briefly mention, we talk a lot about non-judicial alternatives to prosecution and detention for children who have an association with an armed group. In this context, some of the examples that we've seen of that kind of approach include truth and reconciliation commissions, which are forums for hearing children who might have committed war crimes and try and facilitate kind of reconciliation in that way. There are traditional justice systems that are sometimes used, and there are also reparations mechanisms that are sometimes used as alternatives to kind of formal prosecution and detention. The second area of advocacy is really strengthening counterterrorism laws. So in many countries, as has been mentioned, counterterrorism laws are often at odds with child rights and juvenile justice standards, and it creates some ambiguity about which law should be applied. Since 2001, at least 140 governments have adopted counterterrorism legislation, which often makes no distinction by age, for action, or association. So such legislation aims to recognize the gravity of terrorism-related offenses with a real focus on a punitive approach, and that's contrary to juvenile justice standards, which prioritize reintegration. Where possible, these laws should refer to the country's national legislation protecting children's rights. So one example is in Tunisia, which has a counterterrorism law, and in that law, they have a specific provision that states that the juvenile justice laws are the ones that govern or control the actions of children. In addition, the law should prohibit the criminalization of association with an armed group or forces for children under the age of 18, and it should end the detention of children based on family ties. The third area is governments should develop a comprehensive law on the rights of the child. And this exists in some countries, it doesn't exist in others. But it's important that in that law, there are provisions that recognize CAAFAG as victims and that criminalize the recruitment and use of children. So that shifts the responsibility of the acts committed during the period of association from the children to the adults who recruited them in the first place. Quite recently in the Central African Republic, such a law was adopted that quite clearly highlights that CAAFAG are in fact victims. So that's now codified. So with that, I'm happy to take your questions. I hope that was useful, and I look forward to the discussion later. Thank you.
Thanks very much, Janine. We will take questions when we've had all of the presentations. Just to remind people, I think a couple of people have their hands up. If you can put your questions in the chat box, then we can pick them up and make sure that we provide them to, or give them to the relevant presenter to respond to. If we can now move to Bridget, who will also be able to give slightly broader and important considerations for CAAFAG. Thanks, Bridget.
Good morning, afternoon, evening from New York. Thanks so much. I'm really pleased to be here and be part of this discussion, and thanks for inviting me. You've heard from Julia about IHL human rights frameworks. You've heard from Janine about some tools that are available, or some ideas for advocacy. I'm going to speak about some of the same issues, but I'm going to try to do it from a bit of a different point of view, from the sort of practical, what do we do when we're in the field? How do we grapple with these? So first, I want you to take a moment to think about how and where you may have heard or read about these terms. What is violent extremism? Who is a violent extremist? Who is a terrorist? What do we consider radical ideology? And indeed, what is radicalization and de-radicalization for that matter? We've seen these terms often just all around us, right? On television, in the media, newspapers, on social media, politicians, and even just in everyday life. We use and we hear these terms. Now, one of the biggest questions is who defines these terms and how? And I think many of us have ideas in our own head about what we would mean by these terms. But as Julia said, there really is no agreed definition. So from a legal perspective, there's no agreed definition. And this means that it can mean anything to anyone. And you can think about the different types of groups that are out there. For example, Black Lives Matter. Remember that the movement, which is ongoing, but was really prominent at one point. And some people really called them violent extremists. Is that what we mean, or what you mean when you say that, use that term? So often these terms have an ideological component to them, and there's some assumptions about ideology. But ideology, in fact, when we look at the evidence, is rarely the determining force for children to associate with an armed group. Generally speaking, there are other driving factors. So we see these terms, next slide. We see these terms sort of, they come from political and security-driven designations. And in the UN, and also in the international community, and in the work that you may do on the ground, we focus on two UN, the UN designated groups, which is ISIL and also Al-Qaeda and their broad affiliates. So in addition to that, however, there are other designations, and I think Julia mentioned this, that countries, regional bodies are making their own designations. For example, in the United States, the US currently has 68 different groups designated foreign terrorist organizations. So that's a political designation, or some kind of a process that they use, but other countries also do that. So as you can imagine, these designations have impacts, and also they're driven by domestic considerations. And we're seeing more and more often that governments are actually using these designations as a political tool. So for example, designating political opposition as a terrorist. Or even if they're not formally doing that, they're using that term in the media. They've used it against journalists, they've used it against humanitarian workers, ethnic minorities. So we see it playing out in ways that are really politically driven, as opposed to factually driven. As Julia said, there isn't that definition even that allows us to make that clear definition. So, and you can also imagine, even in the international community, one country might designate a particular group as a terrorist group, while another might view that as a sort of a freedom fighter. So there's conflicts between and among countries about those designations. Now, how do they impact children? I think you've heard a lot about it. There's these broad definitions of terrorism and terrorist acts. And one of the things that's so challenging about this is sometimes they're so broad that people don't even know what's prohibited. They're vague. And so something where, if you think about a CAAFAG, a child associated with an armed force or group, something like being a driver, standing guard, or cooking for an armed group, which is a kind of a typical activity that a child might do, this could be prohibited. Whereas cooking obviously is not prohibited. Generally speaking, it's not a criminal act. It's something we do every day. So these types of activities can be criminalized, and people may not even know that. So the other thing I wanted to mention was also this counterterrorism and preventing violent extremism is also wrapped up in this. These approaches are not necessarily neutral, and they're used, and in a way, as have been said, they've undermined child rights and putting those security concerns above the best interests of the child. Now, that being said, we have to be really aware that I'm sitting here in New York City, the place where September 11th attacks took. And even more so in conflict situations around the world where there's ongoing conflict. Millions of people have been targeted by different armed groups. They've committed indiscriminate acts. There's extremely violent, and they create fear and pain for people. So we need to really accept and grapple with the profound impact that these groups have on people, and the need for justice. So one of the things that I think is really hard for people, and we've seen from UNICEF point of view, is our teams are wondering how do we grapple with this tension between security and human rights? There seems to be an evident tension, but honestly, there should not be tension. Security and human rights protection are actually mutually reinforcing. We've seen that where states, Janine was talking about the fact that there's been this real increase in children who are detained. Children who have been released from armed groups or who may have escaped, they may think that their government would protect them. But when they actually get released, they become incarcerated. They perhaps are beaten or tortured or some other thing because they are considered to be associated. So that lack of respect for their rights and their lack of fair treatment actually can contribute to a cycle of grievance against the state. So that actually will increase insecurity as opposed to decrease it. So next slide. So I wanted to also just talk a little bit about the narrative that we're seeing in the media, and again, to have people think about the language that you're using, that your colleagues are using, that your organizations may be using. We have seen in actually senior UN officials, in the media, using terms like these children are ticking time bombs. I found in one media story, they called young children jihadi kindergartners. So if you look at those terms, you can see the first one, well, they both. The first one is almost like weaponizing a child, right? Turning a child into a clear threat. Okay, and that's different than how we've treated children or viewed children in the past. So children in other wars, we're very much treated as victims, right? As victims of human rights violations. So from a legal perspective, they should be treated like victims because they are a victim of child rights violations, but of course they have some agency. So many of them are survivors. So as humanitarian actors, we also use terminology that perhaps creates this kind of stigma. So you have to be careful of that. And I actually have tried to really be thoughtful and intentional about the language that I use so that we're clear about what we mean. And this goes back to the point that Julia was making. Children are children, no matter who they are or where they are. Sometimes we use terms like, and when I was in Iraq, I heard colleagues using the term ISIL babies. This again creates a terminology, and it can be kind of a shorthand that people use not intentionally making a stigma, but perhaps perpetuating those stereotypes. And actually, it's undermining the work that we want to do together. I wanted to mention the continuum of coercion here. I think some of you are probably familiar with, but if you're not, I really commend to you the study Cradled by Conflict. And there's a technical note on programming which describes the continuum of coercion. And this is what I'm getting to here, is about the choices that children make, right? When they become associated. And so we need to understand this if we're programming for them, when we're talking about prevention and when we're talking about response. The continuum of coercion is about that span from those children who were forcibly abducted, forcibly recruited, across the continuum to those who appear to maybe have joined voluntarily, completely voluntarily. When you look actually at this continuum of coercion, what you're seeing is actually, and this is true of all children are associated with all types of armed groups, not only those designated as terrorists, but they often are making decisions based on several bad choices, several choices that are really informed by deprivation, whether it's simply that they don't have enough food, they're not able to protect themselves, their families are not able to protect them, or they're living under the control of a group and they simply don't really have a choice. So as much as it seems like a voluntary choice, there's coercion across that domain. Next slide. So other things that I wanted to highlight for people to think about is about instrumentalizing services. So I wanted to talk about this because we see, and this goes to a bit to the de-radicalization point. Often we talk about, or it's programming is described as de-radicalization. And I mentioned before that ideology is rarely the main motivating force, although it becomes more prominent if a child is actually associated. Ideology and adherence to an ideology can be essentially a survival mechanism. So what happens is that is starting to happen is that the services that humanitarian actors provide and that governments provide, education, youth empowerment, resilience programming, what is starting to happen is they are becoming instrumentalized by for counterterrorism objectives. So education, for example, is used to counter violent extremism, quote unquote. Youth empowerment, same thing, as opposed to having education for the purpose of educating people. And from a programming perspective, there are some risks associated with that our staff needs to be careful of. And as well, when you just look at what you name your projects, for example, if you were running a program for youth around violent extremism, perhaps those youth might not want to join that because they might say, well, I'm not a violent extremist, but they might want to join something that's around youth empowerment. So looking at the access and the willingness and the uptake of programming, it can be infected by using these same narratives. I said before about stigmatization of children and communities, and that stigmatization, that separation, that isolation can actually exacerbate conflict. It can exacerbate feelings of not belonging, and it can actually hinder reintegration in the longer term. Next slide. So additional things, okay, I won't talk too much about detention. Janine mentioned that, but that's a huge consequence of the designations of armed groups as terrorists and children there. The refusal to repatriate children. You've seen children who have been traveling across borders or who have been brought by their families. That refusal to repatriate has a major consequence. There's also major programming on what is called prosecution, rehabilitation, and reintegration. There are donor restrictions on our funding, and there's provisions on prohibiting material support for terrorism. Next slide. Those can all have impact. Okay, so what do we do about this and how do we engage? How do we kind of get rid of our discomfort, right? I've talked to many colleagues and there's just a feeling of discomfort with this agenda. And my answer to this is to start by going back to the basics, putting child rights at the center. Christine said in the beginning, right? Think of Lord Resistance Army. Think of the FARC in Colombia. Think of the LTTE in Sri Lanka. All of them recruited and used children in vast numbers, subject them to severe violence, deprivation. They were highly ideological. There are, of course, differences between them and what ISIL has done, but the experiences of children in those armed groups is not actually fundamentally different from the exploitation that they experienced in these other groups. And yet we're treating them differently, and we're thinking that somehow our approaches might not work. There isn't any evidence that that's necessary, that a massive change is necessary. Yes, we need to contextualize, but do we really need to treat them differently? It's worth interrogating why we are treating them different. Why do we think we need to treat them differently? Why should our approach be different? Is it really that they're exceptional? And I submit to you that it is not. So one of the things that I would want people to focus on is the Convention on the Rights of the Child and their optional protocol. So everything that Julia spoke about, right? These instruments, we are comfortable talking about them. We're comfortable talking about the right to life, survival, development, the right to be free from arbitrary detention and violence. We're comfortable with talking about children who may have committed crimes and how they should be treated under juvenile justice law, the right to fair trial, the right to representation. We're comfortable with them, we know them, and these children, they deserve no less than that. So focusing on these things that we are comfortable with, that gives us the vocabulary that we need to talk about these children. And there's no need to create another separate vocabulary for them. So if you're asked, well, what about those children who are detained? They might have committed a crime. Well, indeed, maybe they did. So what do? We go back to the basics. We go back to juvenile justice law, as Janine said. We go back to what is in a child's best interest, right? These things we can do and we can feel comfortable with. We go back to these guiding instruments and we try to get comfortable with these other actors, speaking with military, with intelligence, not just talking to ourselves, right? Try to grapple with that. And honestly, they'll expect us to talk about child rights. It would be strange if we didn't. So in terms of programming, just maybe a few things here to wrap up. Number one is basically don't focus necessarily totally on ideology. Really focus on that programming, what we know works, the MHPSS, the family tracing, the support that children need, getting them released. Work on against stigma. What we see is across the board, the stigmatizing language and approaches. Get comfortable using your tools, the tools that you have, and believe and have the confidence that you have that. And then openly think about how you talk about these children, talk about these groups, talk about families who may have some links to them. I could say more, but I think I'm over my time, so I will end there. Thanks a lot.
Many thanks, Bridget, for that really sort of thoughtful presentation and making us really think about how children are perceived and how we are perceiving children as well. We've got just under half an hour, so we'd like to move to a Q&A part of the session, the webinar. Sandra and I have been looking at some of the questions that people have been posing in the Q&A. We noticed there are a number of comments as well as questions. Bridget, if we can come to you, just on the back of your presentation and the points you were making. We have a question around appropriate support, particularly from a mental health perspective, to children who have been associated with groups designated as terrorists. I'm aware I'm putting you on the spot a bit in coming directly back to you, but what would your recommendations or reflections be on appropriate support to children?
Sure, I'll take that one, no problem. So one thing I wanted to highlight on behalf of the CAAFAG Task Force, of course, is that there is a resource pack on MHPSS for CAAFAG that's available. It's on the CAAFAG website. Someone can probably put it in the chat, the link to that. It needs to be field tested, but the approach is, as I said, it's to go with what we know. We know that these children have, like children in all armed groups or forces that have been associated with them, they will have experienced violence of multiple types. In fact, recruitment and use is one of those violations, the grave violations of child rights, which often comes with second violations, whether it's an abduction, whether it's sexual violence, other kinds of deprivation. So often children, when they come, and it's unsurprising, I'm stating the obvious, children will have experienced distressing incidents and will need MHPSS. So we use MHPSS approaches as for any other conflict-affected child. Should be tailored, of course, to the child's needs. If they need a higher level of care, hopefully they are able to do so, to access that. But certainly I would recommend to take a look at that resource that we have on the CAAFAG Task Force website. This operational guidance, it was a resource pack, sorry. It was developed along with the IASC group on mental health and the children and family subgroup of the I'm not going to get the acronym right, but so it's really was developed by MHPS experts, and it's focused on CAAFAG. Over.
Thanks very much. And just to mention, the MHPSS guidelines are available on the CAAFAG Task Force website within the Alliance. Gio, thanks very much for providing the link there. I hope everyone can see that. If I can come to you, Julia, we have had a couple of questions in the Q&A on the importance of international human rights and IHL in relation to children, particularly a question from Tinga Jean-Marie Sawadogo. Are you able to respond to this?
Yes, Christine, sorry, can you repeat, or can you say which question?
Yes, you'll see the question in the Q&A from Tinga Sawadogo asking about international IHL in relation to the issue.
Well, so it is difficult to identify the children and how it is possible to. I am reading it in French. Sorry. I mean, if I understand well, it refers to like the specific protections for children. Christine, is that okay?
Yes.
I mean, if I say under IHL,
yes.
there are general and specific protections.
Yeah.
And of course, I'm just about is it the question about the whether a child is a victim or the other one?
I'm just trying to find things to allow her to explain the question more thoroughly. I
mean, otherwise I can just make a few statements that are important in general in this regard. I mean, it's legitimate that states enact legislation to counter the activities of armed groups designated as terrorist, right? And that legislation and policies and measures just need to be in line with international law. And then we have in IHL general and specific protections for children. And so the specific protections of children, I mean, that children are victims is and that they deserve special care is a very old recognition that has been established for 100 years. I think, Christine, we can say it here that almost exactly 100 years ago in early 1923, the International Save the Children Union in Geneva, with the support of the ICRC, drafted the text which was subsequently endorsed by the League of Nations General Assembly in 1924 as the World Child Welfare Charter. It was the first human rights document adopted by an intergovernmental institution, and it stipulated, quote, "The delinquent child must be reclaimed." So this is a historic commitment to the protection of the child without exception. Even a delinquent child has a fundamental right to be reintegrated into society. And so going back into IHL, I mean, specific protections are due to all children because they refer to the fundamental identity of the child. So this is in recognition of the fact that a child is different from an adult because of their age and their dependency on adults, and hence their specific vulnerability. So this is why all children must be treated primarily as victims and not as security threats. Now, indeed, there is, of course, the problem that a child can be targeted if they participate in hostilities I mean, under international humanitarian law. And that's why it's so important to look also at the legal instruments that were, or that may have been ratified by a state that is concerned, and to advocate, of course, for endorsement of the strong legal framework, endorsement of also the Paris Principles, because these are the tools we have at hand, which are very good. So for the vast majority of states, I mean, just to be clear on that, recruitment by an armed group is prohibited. That is in line with the optional protocol on the involvement of children in armed conflict, which has been ratified by 172 states.
Great. Thanks very much, Julia. We have a question here around children who are born of sexual violence within the context of individuals who are associated with armed groups. Are children born of sexual violence considered CAAFAG, noting that it is when biological father is a member of a terrorist group? Janine, would you like to answer this?
Yeah, sure. I'm happy to, and yeah, feel free to jump in. But no, so as we were mentioning before, you cannot, I think there is a tendency under counterterrorism laws to classify children as members of a designated armed or terrorist group based on a family tie. And it has to be your direct participation that makes you a member of that group. You cannot, by extension of your family, be considered, or rather, yeah, be considered a member of an armed group. And that extends to children who are born of sexual violence as well. They wouldn't be considered members or CAAFAG, children associated with an armed force or an armed group. They would be considered victims of the conflict, but they wouldn't be considered members of that terrorist group because of a family affiliation, even though there is often this tendency to try and lump children, wives and others in the terrorist group, even though there is no direct tie or link to that group. It would require their direct participation in that group to be considered an associated member.
Can I also jump in on that? I think it's a really important question, because and it goes to this also children, not necessarily who were children of mothers who've experienced sexual violence, but generally speaking, the children of adults who may be considered to be associated or perceived to be associated. This question of their involvement in the armed group with, so criminal responsibility is individual, period, right? When you hold someone criminally responsible, it's for their acts, it's for their mental state, right? Evidence has to be against them as an individual, right? So if you're talking about a group, a family, a community, unless you have that individual evidence, they should not be criminalized. So that's why when we're talking about how national legislation and counterterrorism legislation can be so broad, if the term associated with is so broad to include entire communities or families without respect to individual criminal liability, it's actually a violation of many different legal standards, not only in respect to CAAFAG. Now, specifically for children of women who may have experienced sexual violence and are born as a result, there's a real question about the stigma that's attached to that. And I also noted inside in the question, there's in the questions, there's also a question around children's access to identification, civil documentation, birth certificates, and etc. This can also have a major impact, and it's related because sometimes children are born, they're not able to identify the mother doesn't want to identify the father. The mother doesn't know who the father is because she experienced sexual violence. What happens then to the child? In some places and cultures, you must have a father's name. Without that, it's very difficult for you to get identification, or they wouldn't recognize the records of a non-state armed group, right? Even though that establishes your birthplace and parentage. And that means that children don't have access to identification. It's actually a critical issue for children to have access to those documentations in order for them to actually access their rights to identity, name, nationality, education, all those other rights are contingent on some of these documents. And so it's the issue of stigma related to that particular group is really, really important. However, they would not be considered traditional CAAFAG because they are not recruited and used by the armed group, which is the definition of a child associated with armed force or armed group. Thanks.
Thanks very much, Bridget. There's another question that has come up here, which I thought you'd be well placed to answer. It's from Lisa Mashina. I hope that I've pronounced that correctly. Apologies if I haven't. She asks, what could be a way forward in order to make states complying, enhancing, and reviewing their legal counterterrorism frameworks to better take children's rights and their adequate protection into consideration? What
Who are you directing that
initial
to?
Thoughts and questions to you, Bridget?
Okay, just wanted to make sure. Yes, well, I think Janine actually covered this really well in her presentation, just in the sense of, I mean, it's hard to make any state comply per se, but I definitely think that one of the major advocacy points, and sort of we do two, kind of the upstream and the downstream, right? Engaging directly with states around their national legal frameworks. And one of the things that Janine really identified was looking at counterterrorism legislation and making sure it actually says explicitly that children are excluded from that legislation, that in fact children should be treated under national juvenile justice law. So to the extent that a juvenile justice law exists in a country, that should apply to all forms of criminal conduct, right? Whether it's a terrorist act or sort of a run-of-the-mill theft, for example. The rights of the child are the same and should be the same, and that's really important. And the Committee on the Rights of the Child has the General Comment 24, which also talks about the need to not prosecute children under special courts, as Janine said, the military and or intelligence courts, but civilian courts. But where in some places, of course, there are no specialized juvenile courts. So then what do you do there? That doesn't mean you're without options. Then the point is, how do you work with actors, juvenile or justice actors, to train to, okay, but then it should be in a civilian court and perhaps with people who are specially trained to work with children. So there's various steps till you get to that ideal system of having a separate court. But I think doing that upstream work, reviewing legislation, seeing how it might apply to children or be used to apply to children, and really working on amending those laws to really make clear that the state is actually taking its obligations under the CRC and other juvenile justice standards seriously.
Thanks very much, Bridget. Julia, if I can come back to you, we've had a couple of questions in the chat in relation to the situation in Americas with children who are recruited or associated with some of the criminal gangs there, and particularly the situation of the potential of being detained. I wonder if you could just give us a bit of a clarification between or on the distinctions and differences between children associated with armed forces or armed groups and the rights of children associated or linked with criminal gangs.
Thank you, Christine. International humanitarian law is the body that applies specifically to situations of armed conflict. So where you have these situations like are described, there is no armed conflict as such, and therefore that those laws, IHL, cannot be applied. Maybe just to say quickly the criteria that need to be met for a conflict to be considered an armed conflict or a non-international armed conflict. They are that the armed group, so the armed group designated as terrorist or whatever armed group, needs to have a minimum level of organization. It needs to control a territory actually on which it can stock its equipment and then develop strategies and train the troops, etc. So it needs to control part of a territory and then be engaged in an armed confrontations against that state. And these armed confrontations must be of a protracted nature, and they need to also reach a certain intensity. So these criteria are quite clear, and only in the case that they are met does IHL apply. So in the other situations, it's human rights law.
Thanks very much. Sorry, I put myself on mute there. Janine, we have a couple of questions on handover of protocols, particularly sort of where more information can be found on them and whether they are publicly available. Would you be able to respond to this?
Sure. So these are typically are not publicly available. Normally, they are agreements with the UN or the UN peacekeeping mission and the government in question, or in some cases, a non-state armed actor. However, in the guidance note that I mentioned in the presentation that I just did, which is available on the Watchlist website, but also if you look at the Q&A, Sandra has provided links to it as well on the Alliance website. What we've tried to do is provide a template which basically consolidates all of what we believe to be some of the best provisions in existing handover protocols that people can use as a guide when they're going through their own negotiations to sort of be able to take a look at different provisions that you might want to consider, how long it takes for people to be handed over, what are conditions should children be kept in when they are in the custody of military actors, a whole range of different provisions that basically build on, I think there are about 10 or 11 handover protocols in existence at the moment. And we had the opportunity to look at some of those and try and pull out some of the strongest provisions to help guide future negotiations. So that is available at the end, which might be helpful.
Great, thanks very much. We've just got just under 10 minutes left for our webinar. I think we've responded both verbally and written in writing to most of the questions that we've got. Apologies if we've missed them. We will go back through to make sure that we've responded. A couple of colleagues have got their hands up, and I think we have a wee bit of time just to ask them to come in. I'll see if I can allow them to speak. Fiona, you have your hand up, and I'll see if I can allow you to speak, allow to talk. Hopefully that will work. Fiona, did you have a comment or question?
Oh, no, nothing from me. Thanks, Christine.
Yes, thanks. Please go ahead.
Christine, was that for me?
Yes, it is.
Oh, thanks, Christine. Thank you. And thank you. Firstly, thank you so much to the speakers today for all their really interesting engagements and their really fantastic inputs. Really, lots of food for thought there. I mean, one issue that I've raised with Bridget in the past is, and this has been covered really carefully and helpfully in today's session, really relates to the kind of dichotomy between the approaches that some of us take in terms of looking at children as victims and others who take a more kind of hardline securitized approach, particularly sort of in our defense and security sort of teams, and how we reconcile those and help colleagues to understand the child as a victim when there are two very different discourses in operation simultaneously. Bridget's given some really good advice on this, but if there are other colleagues who would like to come in with some advice born of practical experience on how we do that reconciliation, I would be really grateful. Thanks very much, Christine.
Thanks very much, Fiona, for the question. It's very useful. I will just go back to the panelists to see whether they have any thoughts themselves that they can share. I'll come to you first, Janine, whether you've got anything to respond to that. I'm aware of slightly putting you on the spot there. But any initial thoughts that you may have?
Yeah, I mean, I don't know that I have too much more to add, but I do think the approach that Bridget has outlined is an important one, which is the protections for children do exist in international humanitarian law. The standards are there. And I think being able to step back and go back to those standards is an important starting point in these discussions. I think there's often an awareness raising and sensitization that needs to happen for some security actors on those standards. Having done a lot of research and work around handover protocols, often the prerequisite for these negotiations for handover is actually a couple of kind of educational sessions for actors that might not typically be, when people are designing security laws or counterterrorism laws, children are not often at the forefront of those discussions. And you can see it reflected in the law. Often they're overlooked, or there haven't been provisions carved out specifically for children. And I actually think there is a lot of awareness raising that can be done among actors that are not typically involved in children's rights issues and work, in just bringing them up to speed on some of the protections that do already exist. And I do think, as has been outlined already, that is a good base and starting point. This is one of the situations where I think the law is actually on the side of child protection actors, and being able to use that as a base can be a good means for advocacy.
Great.
That's really helpful. Thank you so much for that. We're doing exactly that. And I think it does bear some fruit. So grateful to you for that input.
Super. Julia, did you have anything to add to Fiona's question or comments?
Thanks, Christine. So indeed, it's what has been said by the other panelists is very relevant, of course, and I can only say that it's of course also a difficult task when you you try to, convince someone, and you always think of new strategies of what more you could say and so on. But maybe to break down the problem to smaller problems can be an approach also important, to know the domestic legislation of a state well. What minimum age of criminal responsibility do they have? And maybe that could be a discussion that takes place. For example, the recognition that there must be a minimum age of criminal responsibility below which a child may not be prosecuted, and that this is an expression of the specific safeguards that children are entitled to. So, I mean, already to pass the basic idea that because of a child's vulnerability, because of their identity as a child, they are entitled to special protections. And then to also say that in a historical context, that it's been there have been various conflicts where children have been engaged in extreme violence, and nevertheless they should be regarded primarily as victims and children, and that actually that there might be only some provisions of the bodies of law in a state that are problematic, and in other instances they do actually set, for example, this minimum age of responsibility, or recognize that a child is a child and needs to be treated differently. So what is really problematic is when counterterrorism laws give powers of arrest, detention, and even the ultimate sentence of the death penalty without specifying a limit in terms of age, or without highlighting existing legal safeguards specific to children. I just think one other comment about when we do advocacy strategies is also to identify the contacts, the people we talk to, who often in a state there are some that are more inclined to respecting children's rights, and others that are more hardliners. But actually sometimes those that are the security folks, or the security people are actually quite they are quite understanding of the benefit also for them to respect children's rights. So sometimes there can be specific interlocutors, as we call them in the ICRC, that can be sensitized, or can be with whom there can be a dialogue on the arguments that they can also use within the state to convince others.
Thanks very much. That's a great point to finish on. We've literally got about 1 or 2 minutes left. So apologies for those colleagues whose questions we haven't been able to answer. As I said, mentioned, we will go back to the questions posed in the Q&A and make sure that we do respond to you. There will be more information available on the CAAFAG Task Force, and particularly the community practice on the Alliance website. And it would be great if you could take the time to complete the questionnaire, the satisfaction questionnaire. Many thanks, Sandra, for putting the link up on the chat. And it just leaves me the opportunity and pleasure to thank Bridget, Julia and Janine very much for preparing and providing information and their thoughts and experience on this issue. It's been incredibly interesting, and I hope that everyone else has found it useful. Thanks also very much to Sandra and Gio from the CAAFAG Task Force for hosting this, and also colleagues behind the scenes who have been supporting the translation, and also just the running of this, making sure that we're working to time, making sure that the presentations are going as wished. And thank you all very much for participating and joining us this afternoon. We'll leave it there. And I wish everyone sort of a good rest of the day or evening your side. Thanks very much.
Right.